What? Like I'm talking to like last week.
Court TNA District Court for County of Washington, State of Michigan is now in session. All those having business for the court are here. The Honorable Judge Simpson preside.
You may be seated. Who's gonna do? Really? Oh, I have the honor of the chief. Oh, excuse me. No, let me sit up. Go ahead.
Good morning, Your Honor. Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people. Your Honor, the people would waive any potential conflict between this honorable court and the Office of the Public Defender. People don't believe such a conflict exists, makes this waiver in avoidance of any doubt.
Thank you very much.
Good morning, Your Honor. Intern Malaika Fatima requesting to practice under MCR 8.120 under the supervision of the Deputy Chief Public Defender, Lauren Brown.
Permission to practice is granted.
Thank you, Your Honor. We do not believe there is any conflict between this honorable court and our office, and if any conflict is to arise, we waive that conflict so that this honorable court can hear these matters.
Thank you. And the court, for its part, also does not believe there's a conflict either under the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the cases of the people of the state of Michigan versus Christopher Nutley.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Nunley. Mr. Nunley, will you please state your name for the record?
Christopher Nutley.
Thank you, sir.
Your Honor, we are asking that these matters be set for a preliminary exam.
All right, all discoveries complete.
I'll yes, Judge.
People have their witnesses available to 12.
That's fine.
All right.
Judge, is that enough time? I'm sorry, for a writ to be done? He is,
Oh, he is. Yeah.
Yeah.
Jackson.
The 19th.
Preliminary examination in person, August 19, 2025, 9 a.m. That is before.
Before you at 12.
Actually, it's at 12 p.m. before me.
Thank you, Judge.
Thank you. Bond will continue. Okay. Court does call the case of the people versus Jacqueline Jones, Washington.
Andrew Childers appearing on behalf of the people.
Malaika Fatima appearing on behalf of Jacqueline Jones, Washington.
To Washington, Jones, can you state your name, please?
Jacqueline Jones, Washington.
Thank you.
Has the court received the report, competency report?
Is this a competency? Yes. All right. I have the report finding that the defendant is not competent to stand trial.
Yes,
Is that
we've
the
sent an
only-
order.
Pardon?
We've sent an order finding her incompetent.
Is there any other evidence?
On behalf of the people, Your Honor. The report does says incompetent but likely to regain competency in the staff.
Say that last part again.
I believe the report references the CFP is seeking time for treatment and they miss Jones Washington can be restored.
They didn't put that in the front of the report.
At the end of the report.
I'm sorry.
It's at the end of the report.
Yes, okay, I see it. Very last one, I see it. She can be restored in the statutory time frame. All right. You said you sent orders in.
Yes, we have.
I do not have them, but what I will indicate is we will set a competency hearing on this deal. I need 90.
October 23rd.
Set a review in this matter, October 23rd, 2025. 9 a.m. Bond will continue.
We need an order
Oh,
by case only.
Your Honor, if I may,
We need an order on the 2025 case only.
Yeah, because it was separated from the other ones.
Got it.
That's-
was there an order sent back in May, I thought? The court doesn't have that?
Which order? Are you talking about the order on the findings? Not the finding, but we need the. Ms. Wildling?
I'm sorry, the 2025 case, there was an issue with the timing of it, so. the
Correct.
2025 case was rescinded. That's the one that needs the order.
Okay. So, okay,
Got it.
good, okay.
Got it?
So it's the 25 case that needs an order.
Yes.
Okay.
Thank you. Court does call the case. People versus Madden Delaney.
Andrew, then.
Your Honor, good morning. Joe Simon on behalf of Mr. Delaney.
Madam Delaney?
Go ahead, sir.
Your Honor, I made a proposal to Mr. Banis. Mr. Banis wants to have the opportunity to talk to the officers about the proposal I made. Wasn't able to make that happen by today, so where the parties are requesting an adjournment of the PCC.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. or as your invite indicates, bond continued.
Thank you, Your Honor.
Thank you.
Thank you.
Court does call the case. People versus Keandre Allen.
Now, is that on behalf of the people, Your Honor?
Zoom created chaos with names, mics, and cameras failing. The judge stepped in firmly. Wrong courtroom, wrong link, get it fixed, and move forward.
Robert J. Coe on behalf of Mr. Allen.
Your name, sir?
Keandre Allen.
Thank you.
Judge, I saw Keandre last night. He wants to proceed to exam. We have the discovery.
Your Honor, I address bond when appropriate.
All right. You said discovery is complete, Mr. Philip.
Yes, you're on 99% of it. We will get the phone calls this week.
People have their witnesses available to 12.
We'll do our best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 a.m.
Judge,
That's before.
I'm sorry, I didn't mean to interrupt, but I have a circuit court trial starting on the 11th. Can we bump it past that?
August 19th, 2025. That's at 9. At 9 a.m. before Judge Moore. As to bond.
Your Honor, it's my intention that since you've been arraigned, I haven't had a chance to listen to all the calls. I have 7 calls from victims. One of the calls I know for sure. The victims listed on the report, and he mentioned his contempt. Judge Washington's court after arraignment. So this time I'll be asking his phone for the police for your vote.
Any response?
Judge, I spoke to my client last night. He assured me he has not made any calls. I would just ask you to allow him to
That
continue.
he's not made any calls?
Correct, is that correct? Not, pardon me?
Correct. Right.
Not to the victim, Your Honor. There's obviously been phone calls, but not to the victim.
Okay, were phone calls made to the victim's number?
No, Your Honor.
Our numbers restricted.
You're saying they were?
I have phone
They're
calls for
restricted
listed
on
on
mine.
the police court, and he mentions his hold on Judge Washington's court first.
So do you want me to listen to that? Because if I do, then not only would I revoke his phone privileges, but I will revoke his bond. and I find out
Judge,
what he's telling me not to be the case.
just cancel the phone calls for now, Judge.
Defendant's phone privileges are hereby revoked, and I've signed that order. Bond in all other respects will continue. Thank you.
Thank you, Judge.
Court does call the case of the people versus Conrad Neary.
Ready, Your Honor.
Good morning, again, Your Honor. Victoria Burton here, Assistant Prosecutor here on behalf of the people.
Your Honor, good morning again. Joe Simon on behalf of Mr. Neary. State your name, Conrad.
Conrad Neary.
You don't have to wait. Just step up, half step forward.
All right, go ahead.
We've reached a resolution, Your Honor. You should have both a plea sheet and an executed advice of rights form.
I do. Plea form indicates that the defendant will be pleading to an added count 3 of use of cocaine, 1-year offense. Upon a successful plea to that charge, counts 1 and 2 in this case will be dismissed. He's also agrees to plead guilty under 7411 and continued compliance with his recommended treatment as part of this agreement. Also, there is the prosecutor will recommend no upfront jail so long as continued compliance with recommended treatment while on probation. That's the court's full understanding of the agreement.
That's ours as well, Your Honor. Mr. Neary filled out an advice of rights form. He's ready to answer your inquiries, and I'm pretty sure the matter's remanded to Your Honor, which is why there's no sentencing judge waiver on it.
That is correct.
Thank you.
May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Conrad Neary.
He's pleading guilty. Is
Yes.
that correct? Okay, because I have a report. All right. Sir, it is this court's understanding that you are pleading guilty to the charge of use of cocaine. That's a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
Understanding that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Okay, yes.
You
I
that?
understand. I understand.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
To another court. You're not on.
Oh, no, I'm not. No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty?
Yes, Your Honor.
December 9th, 2024 at I-94 near South State Street in Pittsfield Township, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
Yes.
Had you used it?
It was for your personal use.
Yeah, it was for my personal use.
Okay, and you knew what you had was cocaine, is that correct?
Yes.
All right, sir, I do have to advise you that if between the time of my taking your plea and accepting your plea, you commit misconduct as defined by the Michigan court rules between this time and the time of sentencing, that first of all, you would not be permitted to withdraw your plea. You understand that?
I understand.
And you also understand that the court would no longer be bound by any type of agreement or evaluation of your case.
Yes. Yeah.
All right. Counsel, is counsel aware of any other promises, threats, or other inducements which have caused this plea?
Defense is not.
No.
She was concentrating. And have I complied with the court rule and would it be proper to accept this defendant's plea?
So satisfied.
Yes, Your Honor.
Court will accept the defendant's plea guilty to count 3. Counts 1 and 2 are dismissed. The pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
August 27th at 12 p.m.
August 27, 2005, 12 noon, before me.
Thank you, Your Honor.
Thank you. Bond continue.
Thank you, Your Honor. Wait with your mom right outside.
Court calls the cases of the people versus Todd Rayberg. Send in for Jay. Yeah. Oh, yeah, sorry. Yeah. Easy.
From light courtroom banter to tough rulings, the judge's stance stayed firm. Miss a test, miss court, face immediate consequences.
I don't know. You already do. Okay. I'm not. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Rayburn.
Kyle Burrell with and on behalf of Mr. Rayberg in the case ending in 0891.
Assistant Public Defender Jay Bellinger on all cases not ending in 0891, Your Honor.
All right. Your Honor, so Mr. Rayberg has a number of other matters pending. So at this time, we are asking for an adjournment to allow everything to sort of catch up.
Yes, Your Honor, we have all the orders signed for his cases today. I understand there may be some cases pending, but as of today, we are just waiting on a bed availability for him.
All right, so you're asking for an adjournment also?
An adjournment also, Your Honor.
All right. You're looking for at least 3 weeks? Is that?
Yes, Your Honor.
All right. Probable cause conference in these will be adjourned to August 19th, 2025, 9 a.m. All right, that's a Tuesday, just short of a 3-week time frame.
Thank you, Your Honor.
Bond will continue. Thank you. Court does call the case of the people versus Seth Priester.
Okay, originally, the people on this end of the case as well.
Good morning, Your Honor. Wendy Barnwell, P42-505, on behalf of Mr. Seth Priester.
And Judge, not that anyone asked, but I'm the co-defendant's attorney, Mr. Henning. Just in case I'm needed, I'm here. Good morning.
You kind of snuck up there.
I did, yeah. A little shorter today.
How come you didn't do something? No, it was a threat to me.
Definitely a threat.
Do we have it?
We don't have the defendant.
Well, what are we doing on Mr. Priester's case? And the other case, I guess we'll bring him out, but.
Well, with regards to my case, I think Mr. Priester's case, I think we were ready to set for exam.
We were requesting an examination.
All right. Is everybody going to be ready to go on the 12th?
The 12th is okay. That works with Ms. Barnwell.
One split second, Judge. One split second. I'm trying
Why does when this case is called, it takes so long? Not looking at who might be the problem. No. No, it's okay. I guess.
Okay. You said the 12th? One split second. Oh. What do you know? The 12th is available. I'm available on the 12th. Thank you. So happy.
So in the Priester matter, until Mr. Henning gets out here, preliminary examination in this matter will be in person. It will be set August 12th, 2025, 9 a.m. That is before Judge Freshour. Bond will continue. And hold on one more. Who do we have? You have Henning? Court calls the case of the people versus Henning.
And Christina Costantino on behalf of Mr. Henning, if I didn't already put that appearance on. Mr. Henning.
Sir.
Devasseer Henning.
Thank you. All right, and in this matter, your house, you have indicated requesting a preliminary examination, discovery is complete.
Yes, Judge.
People could have their witnesses available on that date. I can set preliminary examination in this matter for August 12th, 2025, 9 a.m. That is before Judge Freshour. Bond will continue. Thank you.
Thank you, Judge. Would the court perhaps hear just a very brief bond argument? I'm just asking for a
Yes,
10%
on 200
provision.
cases I have today. Go ahead. I'd love to hear it. Go
I'm
ahead.
sorry, Judge. We're just asking if the court would at all consider a 10% provision of Mr. Henning's bond. He is obviously unable to post the bond where it's currently set. He has been incarcerated now for about 3 months. He has made the very most of his time incarcerated that he could. He's completed his GED at the Washtenaw County Jail, which is not a small feat by any means. He did that within the quickest time that it's even possible to do that. He very much wants to use his new GED to obtain employment upon release. He has wonderful family support. His family's present in the courtroom. They've been present at all court dates. I know that they'll be present in his life if he is to be released. We would ask if the court would consider a 10% provision in his bond.
Response. What was the weapon?
Firearm.
I'm gonna let what I'm gonna do at this time is I'm not gonna give it 10% provision. I think his, well, that would be 25,000. I presume, Ms. Barnwell, you're also making the.
Yes,
that same-
Judge. Yes, Judge. My client is, he's been very compliant while he's being placed at the juvenile facility in the compound there. His mother wants a tether, and I think that would be appropriate.
His bond is set at $250,000. At your client, Ms. Barnwell. Can I have that file back?
Yeah, that is excessive, Judge. I know that this court is aware of the presumption of innocence, and that it's not just a phrase.
Really? Didn't know. In both of these cases, I'm going to modify their bonds. There is a provision that if they're released, they are to go on tether. That will remain in effect. I will reduce the bond to 250,000. I'll give a 10% privilege on that.
And Judge, my client's bond, I believe, was 100,000. It was originally set at, or maybe it was originally set at 250, but it was at 100,000.
What do you have as bond? Well, what I'll do is if it's 100,000, I'm not going to get the 10% privilege on the 100,000. I'll give it on the 250,000.
10%. Okay, Judge. Yes, we would appreciate that. Thank you.
All right. Thank you.
Thank you.
The court does call the case People versus Sherry Walker.
Yes, Your Honor, please, Your Honor, report Brandon Bird on behalf of Sherry Walker.
Defense attorneys asked for global resolutions to settle multiple cases at once. The judge's response? Align your dates, complete discovery, then we'll talk resolution.
Sherry Ann Walker. What are we doing?
I'm just asking, you should have an adjournment.
I do. All right. Probable cause conference in this matter will be adjourned August 14th, 2025, 9 a.m. On continue.
Thank you. You and Your Honor, the court have a great day.
Court calls case of the People versus Mary Collins.
On behalf of Mary Collins, who's at the podium.
Thank you.
Ms. Collins, please introduce yourself to the court.
To the podium.
Good morning. I'm Mary Collins.
Your Honor, so today's a date and time set for probable cause conference. We are working on getting some mitigation documents to the prosecutor that may take a little bit of time, so we're just asking for an adjournment.
You say it may take a little bit of time. What are you talking about?
3 weeks probably would be, you think, could be what we talked about?
August 19th, 2025.
Thank you, Judge.
And bond continue.
We don't know.
Thank you.
You're welcome, ma'am. Court calls case People versus Oreska Dennis. He's back.
I'm back, Judge. Christina Costantino appearing on behalf of Mr. Haruska Dennis, in case number ending in 1150.
Malika Fatima appearing on behalf of Haruska Dennis on the other cases.
All right.
Mr. Haruska Dennis, could you state your name for the court?
Zachary Haruska Dennis, Your Honor.
What are,
Good afternoon, Your Honor. Amy Reiser appearing on behalf of the people.
all right. And what are we doing?
Judge, this is the date and time set for PCC. We would be asking to have this matter set for an exam. I believe that discovery is complete.
The same would be for us. We would like to set this matter for preliminary exam.
People have their witnesses available to 12? Yes. Preliminary examination in person will be set August 12th, 2025, 9 a.m. That is before Judge Valvo. Bond will continue.
Thank you, Judge.
Cases of the People versus Anthony Alfaro Callejas.
Good morning, Your Honor. Zach Bonham on behalf of the defendant who's joining us by Zoom.
Good morning.
Sir, can you please state your name?
Anthony Alfaro Callejas.
All right. What are we doing today on these?
Your Honor, we're
My counsel reached out, we have a discovery, technical issue that we're trying to resolve, so I wanted to put down ahead of everything. I believe, we are requesting an adjournment. I did extend an offer, which he has, discussed with his client, and they're still considering that as well.
That is correct, Your Honor. We're waiting on a little bit of discovery left over. We would ask for this to be reset. And also, when we're done, I'd like to make an amendment to the bond that you granted at the last hearing.
All right. Probable cause conference, August 14, 2025, 9 a.m. As to bond.
Your Honor, you granted home confinement at the last hearing. My client has went to that location. It is quite a distance from where he's working. He has a friend that lives much closer to where he works. I think it's about 15 minutes away. It's a walk for him. And I provided an amended bond order that I sent over to your office, also to the prosecutor's office, so they could see that as well. There's the new address of, I believe it is 4822 Washington Avenue, Unit 15, Ann Arbor, Michigan, 48108. So we just asked that you would amend the bond to allow him to reside at that address for work purposes.
Any objection?
Okay.
All right, I will sign your order on that, counsel.
Thank you, Your Honor.
All right, thank you. Bond will continue in all other respects.
Thank you. Have a nice day.
All right, you too. Hold on now. Court does call the case, People versus Marvin Sullivan.
David Sullivan on behalf of the people.
Morning, Your Honor. Michael Vincent on behalf of Andrew Sullivan.
Hey, good morning. Your name, sir?
Mark Sullivan.
All right. Good morning, Mr. Vincent.
Good morning, Your Honor.
You're requesting an adjournment?
Yes.
Who's, oh, somebody's here with you. Good. How much time did you need?
A lot. Just for the court's information, over the night, we received 700 pages of a report. And more to, we're picking up even more information from this field. My comment would be cooperative with discovery. The court should know that.
The 19th, which is a Tuesday, or the following week, 28th, which any objection from the people?
Okay.
Probable cause conference will be adjourned August 28th, 2025, 9 a.m. Bond in this case will continue. Court does call the case of People versus Amar Amadou. Amar Amadou? Who's on this? Shocking, it's canon. Come on. Welcome.
Thank you, Your Honor.
No. That was wrong. That was wrong on.
I messed up. Okay. Stephanie Cannon, on behalf of Mr. Amadou, keep your hands out your pocket. Your Honor, Your Honor, I am going to ask for an adjournment, and I will.
Are you?
Yes, a 2-week adjournment.
That long to
case.
decide?
I had to discuss something with my client, Your Honor, that's
just
all.
did that now?
Yes.
Okay.
Yes, that's the thing, yes.
How much time did you need?
I'm requesting a 2-week adjournment.
Are you?
Yes, please.
I bet you I don't have a green sheet.
You do not,
You
Your
are
Honor.
looking all around for one. One's not going to magically appear. We'll wait. Not long. August
I'll do one, Your
14th,
Honor.
2025, 9 a.m. Bond will continue. That's okay. Mr. Brown was filling one out for you, but.
I appreciate it. I will get done, Your Honor.
Thank you. They're bringing more? We don't have enough? What? Court calls the case of the People versus Mario Amison.
Alexander on behalf of the people, Your Honor.
Robert, on behalf of Mr. Amison, is approaching the podium. Amison, please state your name for the record. Mario. Secure. So, Your Honor, there's a date and time set for probable cause conference. I was recently appointed. However, we are asking, I do not believe that there is video in this case, so we are asking that the matter be set for preliminary exam.
And if I could address Bob, feel free, Your Honor.
Why am I not shocked? Okay. So you believe you have all the discovery?
I believe so, Judge.
Would the people have their witnesses available to 12?
We'll do our best, Your Honor.
Preliminary examination, August 12th, 2025, 9 a.m. That is before Judge Freshour. Yes, that's the bond.
Your Honor, it's come to my attention that Mr. Amison has called the victim in this case 100 times since his arraignment. So at this point, I would be asking.
What? 100 times?
100 times.
Okay.
Let me talk.
So I would be asking that his phone privileges be revoked. It's her listed number in this report as well.
Response?
So, Your Honor, I spoke with Mr. Amison in the jail recently. We went over the no contact.
That wasn't on the phone, was it?
No, Judge.
My bad. Go ahead.
Technically, it was, Judge, because it was through the through the glass. So we did have a discussion on it. I explained that the no contact order, even if he receives contact from the complaining witness, he's not allowed to respond. Or to, I don't know, I got it. Or if he is, even if she wants contact, it's my understanding that she does want the no contact order lifted, but we did explain what it means to have a no contact order in place. And going forward, I'm confident he will not be making any more contact and reaching out to the victim at all.
Excuse me.
What do you want to say?
She came and visited me, man. They let her come visit me, so it couldn't have been that serious of a non-contact.
So, we did discuss what the no contact order means. And so at this point, we are asking we're already set for preliminary exam. So, and in the.
No domestic violence or nothing, man. It's a fraud case.
We got it. It's my understanding that the complaining witness has reached out to him several times, and so that he didn't really understand what the no contact order meant. We've explained it. We've hammered down that no contact means no contact. So that at this point
Let me ask this then. Other than those times where the defendant's alleging that the victim has come toward him, are the phone calls his calls out to her?
Your Honor.
Some are from his pin and some are from other pins.
Well, I understand that, Mr. Burdell, there might be a mix-up when she comes there and.
I got one more thing to say, man. You ain't wearing it right, man. Excuse me, can I talk? I know how to talk. I got you. She came.
Sure, go ahead.
She came to the jail to visit me.
I heard you.
I haven't seen nothing, and mail said no contact. How is she able to visit me if it's a no contact order and I'm in jail?
The takeaway? Some walked with PR bonds and tethers, others faced cash-only bonds, and warrants were delayed. But compliance at the next hearing is non-negotiable.
That I don't know, and that's why I asked if there were, I'm trying not to take those contacts where she's making them with you into consideration, because your attorney just explained that you had a conversation about how you have to respond to that. Then I asked, were there phone calls from or contact from you to her, which would be strictly prohibited?
Right. Well, I was under the impression that I wasn't able to have no contact upon my release. They said during bond, we can't be in the same household. They never said about calling her from jail. This is not no domestic violence issue. This is a fraud for $30. That she clearly called the prosecutor and said she didn't want to press charges.
I don't know any of that, sir. I don't.
Because they telling you half the story, man.
I'm not gonna get that information right now. I'm not supposed to have that information right now. Anything else, Mr. Anything else, Mr. Burdell?
No, Judge, not at this time. Thank you.
At this time, and this is only for the calls that he's making now, either from his own pen or from other pens, because that is not allowed and strictly prohibited. Defendant's phone privileges at this time are revoked. You can make the argument before Judge Freshour to reinstate them after the preliminary examination.
Thank you. You fired, man.
What'd you say?
You fired.
Come talk to him, Mario.
You just want me to go? You don't want me to go? You want me to stop on that and say something? You just want me to keep going? Really? Okay. All right. Let's go. I'm gonna pick up the next one and just. This is on your advice, because I got something to say, but I'm not going to. Court calls the case, People versus Nathan Bell.
Assistant Public Defender Counsel Movesi on behalf of Mr. Bell, but not with Mr. Bell. Nathan Bell? I have no explanation at this time. I had been in contact with him yesterday.
You were?
Yes.
How'd that go?
He wasn't on the bus, but we were gonna be asking for an adjournment, Your Honor. I have no explanation for.
Bench warrant, 10,000 cash surety. The warrant will issue immediately.
Thank you, Your Honor.
Thank you. I feel better. Thank you. Always looking out for me. Court calls the case, People versus Virgil Dunlap.
Victoria Burton Harris, Assistant Prosecutor appearing on behalf of the people.
Your Honor, Edward Dukas on behalf of Virgil Dunlap.
All right. Your name?
Roger Dunlap.
Good morning, sir.
Your Honor, there's some outstanding discovery that I'm looking to collect. I'm asking for a few weeks to review everything. There are 2 different matters and search warrants and lots of reports, so I'd be asking for possibly the 28th of next month.
Is he held on anything else?
He is being held. I also have supplied the court with a consent order for a release to treatment and a reduction.
I signed that.
Okay. Nothing else is holding him.
Any objection to the 28th?
No, Your Honor.
Probable cause count, August 28th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the cases of the people versus Robert Galett. Yep. Got it.
Introduction of any of the people. Bob.
Asa Bashir for Robert Galett on matter.
Oh, I'm sorry.
Thank you.
Good morning, Rocky, on behalf of,
Could you state your name, please?
Robert Gallant.
Okay.
All right.
Judge, I apologize. Ms. Reiser, may I approach with our chiefs?
Here now. Your request, both of you are requesting an adjournment.
Yes, Your Honor. We're still working with Avalon, trying to get housing. We have phone calls in the works, Robert.
And we'd request, if it's possible to have a 1-week adjournment. I believe Mr.
If it's got to be 2 weeks, she's going to cover for me. I have a circuit court trial.
Someone from my office, Mr. Yeah.
What?
There's a trial. Mr. Killawald has a trial in 2 weeks, so it'd be possible to have a 1 week.
Why don't we see what date he's picking, adjourn it?
Cause conference, August 14th, 2025.
Go with that.
9 a.m. Bond will continue.
Thank you, Judge, for your understanding.
Court calls case of the people versus Malik Wallace.
Alexander, on behalf of the people, Your Honor.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Wallace. Mr. Wallace, could you please state your name for the court?
Malik Wallace.
Your Honor, we're asking the court to please set this for exam.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available to 12.
We'll do our best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 a.m. That is before Judge Valvo. Bond will continue.
Thank
you, Your Honor.
Thank you. Court does call the case of the people versus Eduardo Benavides.
Victoria Burton Harris, she's the Assistant Prosecutor appearing on behalf of the people.
No, I'll wait. Eduardo Benavides.
Be conversing with the client on one last matter was coming up.
There was an issue that came up. I'd ask.
There was an issue?
Yes, sir.
Is that Miss Akinruli?
Yes. It's. Yeah. No, she's not.
Oh, she's not the issue?
She's not the issue. Never.
Where is she?
Never.
Oh, Your Highness.
Good morning.
They were talking bad about you. I had
Not
you
Mr.
covered.
Brown, though.
Yeah. Oh, no, Mr. Brown was saying the worst stuff. He said you had issues. That's how I heard it.
You shouldn't.
Apparently they didn't finish. the
Assistant Public Defender Tanaka Carey, Your Honor, on behalf of Mr. Benavides. Mr. Benavides, state your name for the record, please.
Eduardo Benavides.
Thank you.
Judge, we're asking for an adjournment today.
All right. Will the 14th work for you?
That should be fine.
All right. During the matter, August 14th, 2025, 9 a.m. bond continued.
Thank you.
Thank you. That's called the case of the people versus Brandon Bowman.
Ally Zinn on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Constable Bass on behalf of Mr. Brandon Bowman, who's present to my right. You state your full name for the record, please.
Brandon Charles Bowman.
Our today's date and time set for a probable cause conference. At this time, respectfully requesting you set this for an exam.
And if I can address bond, Your Honor.
Are you going to address the conditional bond violation report that we have? There's something else?
Yes.
Oh, lovely. All right. You want it set for exam?
Yes, Your Honor.
And you have the discovery?
To my knowledge, yes.
Would people have their witnesses available to 12?
We'll do our best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 a.m. before Judge Fresh Hour. As to bond.
Your Honor, I believe the defendant is in custody on a no contact order of bond violation originally. After he was put back into custody, he's tried to contact the victim 21 times. None of the calls have been successful, but he has tried to call her listed number in the police report. Since being put back in for violating the no.
And at this time, what's his bond? Is it revoked?
I have it as denied, Your Honor.
Yeah, that's what it should be. All right. As to that,
Your Honor, I haven't seen anything about these calls. My client is saying that
I have not made one phone call.
Your Honor, he's going to be asking for a PR bond. He's been in for 8 days.
Is the phone calls that he made, is that attached to his pen?
Your Honor, I'm trying to pull up my internet thing now.
Okay. I understand you're saying that none of the calls were completed, but were they made from his pen? That's what I'm trying to figure out. Well, why don't we do it this way? Mr. Mulvey, you can talk to the prosecutor's office regarding that. If they did come from, I'm gonna, at this time, I'll revoke his phone privileges. I will reinstate them if they did not come from his pen. Okay, so get with the prosecutor's office and I should have that answer as soon as their internet goes back up. All right, sir? All right. Otherwise, bond will continue as denied.
Your Honor, we have it pulled up.
Oh, you do have it? Hold on.
They're from different pins.
They're from,
They're all different pins. There are two different pins that are being used, but not correct.
all right. I'm gonna deny the request then to have his phone privileges revoked at this time.
Your Honor, my client is asking for a PR bond. He's been in for 8 days.
I have a conditional bond violation. That's why he's in.
I understand. He's willing to admit to the bond violation and ask for the 8 days without a hearing. If
that I would not be sentencing him to the 8 days on it.
Understood.
I can tell you that. So does he still wish to admit to the violation? Yeah. Well, that's okay. Yes, I'm gonna need one for you.
Okay. Okay. Understood, Your Honor. Then we'll keep it as it is.
Sorry. One to check your screen. She got ran again. I'm just a figurehead. Court calls the case People versus Anthony Miller. The keys in.
Your Honor, Alexis Pluma appearing on behalf of Mr. Miller.
Mr. Miller, can you state your name, please?
Anthony Lavelle Miller.
Thank you.
Your Honor, I am going to ask to address bond first, if you would allow it.
It's gonna have to be brief.
Okay.
Otherwise, you're gonna.
In a tense bond hearing, defense argued for rehab. The judge agreed only with inpatient treatment. No free pass back home.
Let's file a written motion, show back up at 4.
Okay, understood. Briefly, Mr. Miller's bond was originally set because he failed to appear for a hearing last fall. I do have proof here that Mr. Miller at that time was incarcerated in the Wayne County Jail. He was in from September 2024 to April 2025. He would like you to consider a personal recognizance bond on his behalf because he has a part-time job.
How did he come back into custody?
I believe he was picked up.
So he didn't walk in after he left his time in jail?
He was in Wayne County, then taken to Oakland County, then transferred here. So he was released from Wayne County at the end of April of this year, then went to Oakland, and then was transferred here. So he was not out of custody at any point in time.
That's what I'm asking.
Yeah.
Said he was picked up.
Picked up from another jail is, I guess, what I meant to say. And he would be staying at the Delanis Center if released, but he does have his sisters who live in the area.
Any response from the people?
Your Honor, in the court's discretion, charging the retail crime, so at least in custody, this isn't his fault. I mean, retail crime.
What was his previous bond setting?
He had a personal recognizance bond prior to failing to appear last fall.
Why do I have 25,000 cash surety? Well, doesn't matter. I'll grant that motion. I'll set his bond at $25,000 personal recognizance bond previously declared.
Understood. And Your Honor, I do have a green sheet for him. We're just requesting a 2-week adjournment.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond continues. Thank you.
Thank you.
Case People versus Robert Carl.
Andrew Childers, bring on behalf.
Your Honor, Alexis Kumar again on behalf of Mr. Carl. And Mr. Carl, could you say your full name?
My name is Robert Martin Carl.
I have before me a plea form that the defendant is going to be pleading to guilty to account 2 of use of cocaine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
All right. May I have him sworn?
Okay.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth? So
Oh,
help you
sure,
God?
I do.
State your name.
My name is Robert Martin Carl.
All right, sir, it's court's understanding you're going to plead guilty to the charge of use of cocaine. That's a misdemeanor, punishable by up to 1 year incarceration and a $1,000 fine plus court costs.
I want to be accountable for that, sir. Yes, sir.
What?
I want to be accountable for that, sir. Yes, sir.
Okay, so you understand the maximum penalties in the charge?
Maximum should be a year.
Will be up to a year incarceration, a $1,000 fine plus court costs. You understand that?
Yes, sir, I do.
All right. And understanding that, do you still wish to plead guilty?
Yeah,
Yes, I do, sir.
All right. You understand also, sir, that I will not, while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that, sir?
I never know that, but okay, sir.
All right. Did you want to discuss that further with your attorney?
My attorney,
You're gonna be sentenced in Ypsilanti.
Mhm.
Judge Barr, that's where all your other cases are.
Mhm.
So Judge Simpson's not gonna send you. Come back with me, Ypsilanti.
Or we'll just do it here.
everything. Yes, sir.
All right. You want to proceed?
Proceed.
All right. So to that charge, how do you plead?
Plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
That is correct, sir.
All right. You signed an advice of rights form. Is that correct?
I did, yes, sir.
Okay. You have any questions regarding any of those rights?
No, I appreciate your consideration and I'm accountable for the thing.
Okay. I need you to look at paragraph 5 on that form. You'll see a copy on the podium there. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir, I understand clearly.
You understand you're giving up your right to appeal of right.
That'd be part, yeah, no.
You understand that?
Yeah, I take that, yes.
All right. Are you on probation or parole?
That's incorrect, sir. It's hard no, sir.
Okay.
I mean, no.
Okay. I'll try that again because I want to make sure the record.
No,
is
sir.
clear. Are you on probation at all at this point?
No, sir.
Okay. Are you on parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No promises made that I did not.
All right. Has anybody threatened you or coerced you in any way?
No, sir, they haven't.
You're doing this voluntarily?
This is the,
Okay. You're doing this of your own free will?
Yes, sir, that's correct.
All right. And you're also doing it because you believe that you're guilty of this offense, sir?
I am.
Okay. All right. On the date of March 27, 2024, at the location of 220 Pearl Street, City of Ypsilanti, Washtenaw County, State of Michigan, were you in possession of cocaine?
Yes, but no. No, yes, I was. I just go with that. But yes, I was.
Okay, let's try this again.
Yes, I was, sir.
Okay, let me ask the question. On the date that I just mentioned and at that location,
Yes, sir.
did you have cocaine in your possession?
Yes, sir.
Well, did you?
Yes, sir.
Okay, did you use the cocaine?
Given a chance, I would have.
Okay, so you didn't use it.
I did use it. I was using cocaine. I had cocaine and I was using it.
So you did use it?
Yeah.
Okay. Did you know what you were using was cocaine?
I was very advanced on that information. Yes, sir. Yes, sir. Keeping it simple.
So, sir, if any of what I just say is incorrect, let me know. On that date and at that location, you had cocaine in your possession, you used it, and you knew it was cocaine. Is all of that correct?
That is all correct.
Thank you. All right. Now, sir, I have to advise you that if between the time of this plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rule, you would not be entitled to withdraw your plea, nor would the judge be bound by any evaluation in this case. You understand that, sir?
Yes, sir, I do. Correct.
All right, counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
All right, and have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Defense is also satisfied, Your Honor.
Court accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
August 13th at 10 a.m.
August 13, 2025, 10 a.m. before Judge Barr.
And Your Honor, very briefly, if the court would consider a personal recognizance bond now that Mr. Carl has pled, he does have just recently got his own home in Ypsilanti. through a VA housing voucher, and he is concerned about potentially losing that housing if he stays in custody. He does know what he would need to do in order to get out, and this is the only case that's really holding him. He does have other cases out of 14A2 with low nominal bonds set. He could afford to post those, but not the bond on
I'm
this.
gonna leave that choice up to, I'm gonna deny the request at this point. I will leave that to Judge Barr, who will be able to take everything into consideration regarding this gentleman. So your motion for bond reduction is denied at this time.
Understood. Thank you.
Court calls case People versus Jerry Bigham. So it must have been, he must have been at the time.
Andrew Bannis.
Councilman Lacy on behalf of the defendant, Your Honor.
Your name, Jerry Bigham. Don't bang on my podium. What are we doing?
Yes, Your Honor. At this time, my client is wishing to waive his preliminary exam and seek an offer in circuit court.
Sir, is that correct?
Yes.
Do you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed?
Yes.
Thank you, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Yes.
People also waive the right.
People waive the right.
Preliminary examination having been waived, defendant bound over to circuit court on both counts. Mr. Belvis.
Your Honor, we acknowledge the information. Thank you. At this time, my client waives formal readings and stands mute to the charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
September 18th at 1:30, Judge Slay.
September 18th, 2025, 1:30, Judge Slay. Bond will continue.
Thank you, Your Honor.
Court does call the case of the People versus Sean Dorsey.
Andrew Childers, on behalf of the people.
Morning, I'm Mike Gaddy, Assistant Public Defender on behalf of Mr. Dorsey, who's here to my right and beat me here by a mile. State your name for the record.
Sean Dorsey.
Your Honor, this is the first PCC. We are requesting a brief adjournment so that I've had a chance to speak with Mr. Childers so that we can continue to discuss this matter. We're also going to see if we can't work a release to treatment in this case.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond continue.
Thank you, Judge.
Thank you. Court does call the case of the People versus Michael Boyce Smith.
Good morning. Amy Miser, opinion on behalf of the people. I believe this is.
Yes, it's Miss Ackenrule's case once again.
She was just reviewing the video.
What, she was reviewing what? Video?
The video of it. She couldn't get it open, but ours open.
Oh, was she in with, were you in with your client reviewing video?
I was, Your Honor.
You've had
but
quite a week.
It's, I have, you know.
Yeah, I know.
Yes.
Because all of it's happened in front of me.
We've been
It's
together.
been a
all
mess.
week.
I'm surprised you're still standing.
Just hold it together, Judge. Try it. Good afternoon. No, it's still morning. Good
It's still
morning, Your Honor.
Yes, it is.
Assistant Public Defender.
You want me to pass it so you can look at?
No, it's okay, Judge.
Okay.
Yes.
What would you like to do?
No shows and Zoom glitches didn't stop the docket. Where defendants missed court, the judge issued instant bench warrants with heavy cash bonds.
We would like to adjourn this matter. The court should be in receipt of a green sheet.
All right. Probable cause conference will be adjourned August 14th, 2025, 9 a.m.
Thank you, Judge.
Thank you. She's had a bit. It's only been 2 days, but
And I had a docket after we left.
What'd you say?
I had a docket after we left till 6:30 yesterday.
Did you? You are my hero. Court calls the case, People versus Robin Finney.
Andrew, on behalf of-
And good morning, Your Honor. Laura Yagi, Assistant Public Defender with and on behalf of Ms. Finney, who is standing to my right. Please state your name for the court.
Yes, Robin Lee Finney.
All right.
And Your Honor, I am hopeful that we will be able. Oh. I did send over pretty substantial mitigation, including this newspaper article about all the work my client's done in the community to Mr. Childers. So he is reviewing that, and I think gonna have a conversation with his witness. So we're asking for a brief adjournment.
Probable cause conference, August 14th, 2025, 9 a.m. Bond continued.
Okay, August 14th, we'll be in touch. Good luck. Thank you.
Court calls the case, People versus Savannah Bradley.
Victoria Burke, prosecutor appearing on behalf of the people.
And Laura Yagi, Assistant Public Defender with and on behalf of Ms. Bradley, who's approaching. In terms of the substance, the PCC, Your Honor, we're requesting an adjournment. Ms. Bradley is very eager to get into treatment. We have spoken, unfortunately, she works a lot, so we played some phone tag. I do want to address the bond issue.
So do I.
Yes. So initially, when I first spoke with her, she indicated that she was not aware that it was such a tight time frame within 24 hours of her release, that she was expected to do an intake. She followed up with them, and she did make contact with them, scheduled an appointment. Unfortunately, she didn't realize it was the same time as a psychiatric appointment she had. So she went to her psychiatric appointment, and then she was basically calling them and calling me, waiting for them to call her back. There was a misunderstanding there. I think it was 2 days ago or yesterday, I told her, just go, don't even wait for them to call you, just go. And she was at work and she wasn't able to get there before they closed. So I did tell her first thing this morning to go, but by the time they opened, she was already here. And so we are asking for the opportunity for her to go test today or for her to check herself in.
But after that point in time, she had no further contact with them.
So she is saying that she did call them repeatedly after the 23rd. I know that's not in their report, but that is what she is saying, is she called them and she left.
Very clearly says she failed to report for her intake appointment as ordered. No further contact has been made.
I understand that's what they say. She's saying she tried to call them. Her dad is with her in court today.
So, and when she tried to call them, what they say to her?
She left a message, I think.
And nobody called her back?
That's what she's saying.
Really?
I just want to make two other points. So first, she is a working mom. She is a 9-year-old. I believe she's sole care 9-year-old, right?
If she went over, would she test clean?
I don't know. I think so. I mean, based on my conversations with her, I will also say.
I think it's like a clearest question one can ask.
Okay, she's saying she would test clean. And she's saying she is prescribed to Adderall, and that's what she would test for.
And that's the only thing that's gonna show up?
Should, yeah,
Will or should?
will,
That's it.
yes.
I tell you what I'm gonna do. I'm gonna give you a shot. She needs to go over right now to community corrections, do her intake, take her test, and if you could let them know she's on her way over. If anything, tell them also that if anything comes, you need to come back over here. But if they get the test before you get back over here and something else shows up, take her into custody.
Understood. She is prescribed that medication, like I said, but.
I heard.
Understood, Your Honor.
Get over to community corrections. I'll pass the matter. Court calls case People versus Matthew Fonseca.
People.
Good morning, Your Honor. Public Defender Carson Lubez on behalf of Ms. Fonseca, who's present to my right. Can you state your full name for the record, please, Matthew?
Matthew Fonseca.
Thank you. Your Honor, today is the date and time set for probable cause conference. At this time, we're respectfully requesting to step for exam on both matters.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available to 12. Preliminary examination, August 12th, 2025, in person, before Judge Valvo, in both matters. Bond will continue.
Thank you, Your Honor.
Court does call the case, People versus John Altcock.
Yes.
Stephanie Can on behalf of Mr. Occult, who's appearing by Zoom. Mr. Occult, could you please state your name for the record?
John Paul Alcoa.
Your Honor, at this time, we are asking that this be set for a preliminary exam.
Discovery is complete.
To my knowledge, yes.
And would the people have their witnesses available to 12?
That should be fine.
Pardon?
That's fine. Your Honor.
All right. Preliminary examination in person, August 12th, 2025. 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
Bond continue. Thank you.
Thank you.
Court does call the case of the People versus Nathan Gubachi.
Requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Ron Brown.
Your choice appearing on behalf.
But you thought you had to be right next to her, not in the room?
Where you want me to leave?
Yeah. No, it's always a pleasure seeing you, Mr. Brown.
My pleasure, sir.
All right, so you just stay right there. All right, that makes me happy. All right, what are we doing on this case? Permission to practice it.
Thank you, Your Honor. We're requesting to adjourn this matter awaiting medical records for our office to receive his medical records.
His medical.
Yes, Your Honor.
I mean, I could put it out 2 weeks since he's in custody, but I don't, how fast are they?
May we approach? Prosecute.
Yeah, come on. Came up, that was what it's gonna end up being. Oh, what'd you say? I got it.